CRJ 227, this is your final podcast for this summer. Week 7. For week 8, there is an assignment. Week 8 is a shortened week. Week 8 does not have any new reading, so put in the work this week, please. I need you to read 2 short website pages linked to the assignment forum, and then read the Payne versus Arkansas case and the false confession articles I've also provided on that forum before listening to what I have for you today. And then you're going to present in your own words a recent news story with a working link or a case with a valid citation that discusses specifically an issue related to the police being accused of an improper interview/interrogation. Next, in your own words, you're going to present one, same thing, case or news story that discusses specifically an issue related to a wrongly acquired or improperly obtained confession. These things are 2 different things. You may be able to use the same case for both 1 and 2, but remember, not all interviews/interrogations, and I'll get into that in a minute, lead to a confession. And while an issue or interview procedures or activities may in fact lead to issues with an obtained confession, that's not always true. Again, if you haven't read that case and those articles that I provided, you need to do that before you continue. We don't have anything to discuss regarding use of deadly force this week, but you should think about the one sobering thought that goes to the center of what most of us consider as the primary constitutional protection and expectation for a person suspected of committing a crime, and the dilemma, the heartache, and the conflict that often are caused when use of deadly force silences that person with questionable or worse, no cause. I'm not referencing circumstances in which the suspect is firing on police or raises a weapon and it's all captured on video and uncontroverted, the procedure was followed and use of deadly force was justified. I'm talking about Eric Garner, Laquan McDonald, that progeny. The incidents that caused the reasonable person to know clearly that the action was not proper and someone should have done something different. If they had done something different, a life may not have been taken. And then eventually we get to the interview/interrogation or possibly confession stage rather than what we ended up with in those cases. Now, I've actually been trying to find the time to do a full podcast version and discussion of the terms interview and interrogation. A lot of times they are mixed and, in my opinion, used improperly. In my generation, interrogation didn't come up until we started to militarize police, until we got into the war on drugs and we started to do those kind of things. And we thought about how we deal with society more in those terms. We interview people. That interview may lead to questioning. Now, we interview a lot of people in a typical case before we actually know who the suspect might be. And at that point, once you have an idea as to who the suspect may be, and again, if you're not taking the evidence class, take the evidence class, but for those of you who took the evidence class, we know that you end up with that perception based on the evidence. At that point, maybe it turns towards what we might think of as an interrogation. But I still don't like that term. Many of the people that the police talk to are not to be interrogated. They're witnesses. Those of you who had my civil litigation class last fall know that one of the troubling things for a trial lawyer is when that witness has been interrogated. And we're talking civil cases. No reason to believe that you'll go to jail. So when we are in that circumstance, when we have that situation where most of the people we are going to talk to are going to be able to offer us information, we want to interview them. We're not going to interrogate. Look up the meaning of those two words if you don't know what I'm talking about right here. I'm not going to spend time right now giving you the definitions, but you should Google both. Ask Siri, ask Alexa, whatever you want to do, but you'll see a distinct difference between what those two terms mean. So, I prefer interview. Interviews should be recorded, preferably audio and video. And if that is the case and the law is followed, if that interview leads to questioning and eventually a confession, everything should be fine. But take a moment and remember our old friend Miranda. This is probably the most important element of the interview from the legal point of view. Don't play with it. Don't be cute with its requirements. Cover it by the book the same way every time. And you will get good information. You will have solid investigations. You will have solid arrests. And most likely, those arrests will lead to solid convictions. Just convictions. Historically, many agencies adopted a Miranda protocol that requires an officer to, number one, recite the 4-point warning or the 4-part warning. Number two, ask the suspect if he or she understood those warnings. And then, number three, ask whether the individual is willing to talk. If the officer is confident the suspect wants to talk, an express waiver should be sought. Now, most departments utilize a form that contains the following. Before we ask you any questions, you must understand your rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed for you before any questioning if you wish one. You can decide at any time from this moment on to terminate the interview and to exercise these rights. Do you understand each of these rights I have explained to you? They say yes. Obviously, if they say no, you go back over. But most times they're going to say yes. Having these rights in mind, do you wish to talk to us now? Now, you may have picked up on the fact that I say, do you wish to talk to us? If you have an opportunity to have us available rather than just you, make sure somebody else is there to hear what's going on and see what's going on. And again, as we discussed, multiple times in the past few weeks, most of all of this is going to be recorded if you're doing this as a police officer, right? Body cam, dash cam, multiple cams, public. The opportunity to have it audio and video recorded is pretty likely. And then as I'll share later this week, there's a document that some departments may, if available at the time, have somebody sign. It says, I have read and understand fully each of my rights, and I am willing to answer the questions and make a statement at this time. I do not want the advice of an attorney at this time. I understand and know what I am doing. No promises or threats have been made to me. And they sign and date it. That's before you ever start to question the individual you believe to be the suspect or focus of your investigation. Now, in confessions, in the days before audio and video recording, the suspect may confess during the interview. The persons interviewing the suspect would hopefully confirm the facts of the confession and then have the individual write out his or her version of what they were admitting had happened. Now, there are plenty of horror stories and questionable interview tactics that many of you have or will read about regarding interviews and the eventual confession, back in those days. If the interview is audio and video recorded, you don't get better documentation. So hopefully the interview room is wired and you check the system is working and you get everything recorded. And again, the best way to do that is have multiple people there. So possible, have another person in the room and have somebody outside the room making sure that equipment is running properly, that it is recording. Most departments have this set up in a system that, I'll give the example of Pekin. Pekin has these interview rooms, and you can't see the camera and you can't see the microphone, but you tell the person that it's being recorded, and there's a button outside the room, and you press a button and you walk back in and you commence. Now there's a control room, and hopefully someone is available and in the control room to make sure that the thing's being recorded. But you have that ability. And that's, most departments these days have that ability. Now sometimes a confession comes outside the interview or outside the police station, say in a squad car on the way to the police station. It's not uncommon. Again, many departments may have what's happening within the squad car able to be audio and video recorded. And if that's the case, use it. Use that equipment. And then document the conversation and the confession clearly in your report and attempt to get the individual to write it down and sign their own statement. If you don't have a wired interview room, by all means, get the confession on video and audio anytime you can. Simply getting them to talk about the conversation and confession they gave in the squad car if it came before you got back to the station. So, get it again, document it if you didn't have the ability to get it in the car. And even if you did, a lot of times those things are blurted out in a way and in circumstances that aren't the best. And so go ahead and, make sure you've used Miranda. Make sure you followed the process. Make sure you followed the procedure. Make sure you... Now, what if they changed their mind and what they blurted out in the squad car they no longer want to cop to, they no longer want to admit to? Well, hopefully it was video and audio recorded or there's another person that heard it. But, you're stuck, I guess, at that point. And then it's, the evidence will play its way. As a side note, it's possible and more frequent that video will be available within the squad car as well. So, a lot of times today, the ability to document what an individual says that actually leads to new evidence or leads to a confession, and then the subsequent confession won't be a matter of he said, or he said, she said, or she said, she said. Now, I give the example of a case I worked on in the Attorney General's office when I teach the evidence course, and some of you may remember that, and I'll just real briefly give it to you folks. It's just kind of an example of what it was like prior to video and audio. I handled this case on appeal on behalf of the state. The individual was, it was before the death penalty was repealed. They were facing the death penalty. Chicago police get a call and about a domestic dispute, or what the neighbors called a domestic dispute, essentially, that couple fighting, loud voices, breaking things, yelling. In an apartment building in Chicago. It took close to 2 hours before the police got there. By the time they get there, gentleman opens the door. He's wearing a pair of boxer shorts and a tank top undershirt, and he's covered in blood. He's visibly, and by all indications, intoxicated, if not also under the influence of other things. They go in and they find his girlfriend stabbed multiple times, deceased. Secure the scene, secure him. Eventually he's taken to the precinct where he's put in an interview room. This is before video was available and audio was pretty sketch back then. Not as available as it was even 10 years down the road. This was in the 70s. I got the case in the 80s, 1980s, before most of you were born. And so there wasn't audio and video of all the different times that the police talked to the individual. But what was uncontroverted was that he was put in that interview room, wrapped in a blanket, still in his bloody clothes, for about 8 hours before they took those clothes from him, and they wrapped him, let him get cleaned up, and they wrapped him in another blanket, gave him some, I think, some shorts to wear. Not much for clothes. Don't ask me why. But during that 8 hours, 2 detectives had interviewed to question him. And then they took a break, and another 2 started. And then they were relieved by the first set, and this went on for, without dispute, over 24 hours. At some point, the suspect says, "Let me have a cup of coffee and something to eat and a cigarette, and I'll tell you everything you want to know." Later, by the time I get it on appeal, his appeal is based on a claim that the confession was improperly obtained, that he was under duress, that he only repeated back to the police what the police had shared with him in their multiple attempts to ask questions, that he garnered facts of what they were looking for in those various attempts to ask questions, and that was the basis of his confession, and he was denying, that he had any part of it. The physical evidence was pretty locked down tight, and I guess this is an example, though. If you have video and you have audio, whatever he said and how he said it and all the questions in between, we don't have any issues of. Now, were there problems with the procedure and how they did this? Absolutely. Absolutely. About the only string that we had to go on, it was pretty difficult to defend their tactics. They didn't follow a procedure, even from back then, but the procedures were not what the procedures are today. But we had the physical evidence, and so we had that to work with, and that was a positive thing, and that's essentially what the jury had as well. The jury had the ability to hear that physical evidence that tied him to the actual murder. The point being, follow procedure. It's been the lesson from the beginning. Follow the law. It's been the lesson from the beginning of this class. Okay? And then knowing that things are going to be video and audio recorded, whether by you and your body cam or your dash cam or a member of the public. Damn it, follow the law, follow procedure, do the things you're supposed to do, how you're supposed to do it. And if you do that, you will have a long and successful career, serving others, serving the law, upholding the law, protecting the peace and ability for people to live through the law. This is the final podcast for the summer. I really want to thank you now, since I won't get to say this in my spoken word. Thank you for your effort this summer. I hope you stay well. I hope you stay connected. If you need anything job-wise or anything like that, I'm the guy that posts those jobs on icclaw.net. Always go and check that. We have graduates working all over the place in any of these areas. Law enforcement, criminal justice, paralegal, probation, you name it. And I look forward to seeing you all do whatever it is you want to do within the law, and then be here to support you long after you leave ICC, just like Doc Wright and the people supported me long after I left ICC. And I don't plan on going anywhere probably until most of you are well established in your careers. So thanks again. I appreciate you. If you know or need me, you know where to find me.